All right. Good afternoon and welcome to the Fair Housing Center of Southwest Michigan's April is Fair Housing Month, looking back on the foundations of fair housing and celebrating fair housing. My name is Derek Kusa. I'm the fair housing educator here at the center. Uh, I am a white guy with a sturdy red mustache wearing a cardigan, and let's get moving. So first, we'd like to acknowledge MISTA, the Michigan State Housing Development Authority. Um, this training we're able to present free of charge thanks to a generous grant from MISTA. Uh, Before we get moving too far, I do want to remind everyone that the Fair Housing Center of Southwest Michigan, we are not staffed by attorneys. Nothing in this training is to be seen or used as legal advice. The information is presented for educational purposes only. We are recording this session. And as I mentioned before, um, everyone was in, please post any questions that you have into the Q&A box. We'll be answering as many of those questions as we can at the end of the time, at the end of the presentation, time permitting. And the image on this slide is the MISTA logo. So a quick little agenda here. We're going to start by going over the basics of fair housing. And then we're going to take a look back at what are called restrictive covenants, which are an early and important part of how we got to the Fair Housing Act. And then we'll look at, in this case, one champion of fair housing by the name of Ed Roberts, who's important in the disability movement. So before all that, a little bit about us. The Fair Housing Center of Southwest Michigan, we serve Allegan, Berry, Berrien, Branch, Calhoun, Cass, Kalamazoo, St. Joseph, and Van Buren counties. And we work to promote integration and eliminate housing discrimination through education, advocacy, and enforcement of the fair housing law. By promoting integration, we mean that by pursuing our mission, we aim to reverse the segregatory effects of societal decisions. And by eliminating discrimination, we mean that we aim to remedy the actions of individuals. And we use three tools for this. Those are education, advocacy, and enforcement. Uh, each year, the Office of Housing and Urban Development, or HUD, estimates that of the 4 million occurrences of housing discrimination, only about 11,000 are reported in any given year. So through education, ideally we can eliminate housing discrimination before it occurs, whether through the education of housing providers to know what constitutes discrimination and that it's legal. Otherwise, we can use education to help people to recognize and report the housing discrimination that they may be going through. And after that report, we can advocate on their behalf and we can work to secure justice through enforcement of the fair housing law. And I represented them here cyclically because our efforts and successes and our failures of enforcement, through those, we can gain a better understanding of how better to direct our fair housing education so that it can maximize its impact. So, what is fair housing? Fair housing is the right to equitable access to housing and all related services. So, this is anything to do with getting into or maintaining yourself in a house. So, that's renting, selling, or buying, advertising a house. If you need financing and you're looking to purchase a home, insuring your house, getting your house appraised for a later sale. This list isn't exhaustive. It's some of the more important aspects of the housing transaction, but fair housing applies at all points. And so the goal today is to look back on and celebrate a handful of the stories in the history of fair housing. But before we do that, we're going to go over a few more of the basics of what it is. So in fair housing, we use this formula to determine whether or not something is in fact housing discrimination. And as you can see, it consists of three elements. There's a covered dwelling, a protected person, and an unlawful practice. If all three of those are present, we have housing discrimination. So a covered dwelling, we'll get to in just a second here, but very nearly all residential constructions are covered by fair housing. A protected person is someone who falls within a protected class or has a protected characteristic. I use these two terms interchangeably. The law has it as protected class, but sometimes that can be a little clunky conversationally. So federally, there are 7 protected classes that we'll get to, but these are race, color, religion, national origin, sex, family status, and disability status. State and local governments can add to those. They can never remove those protections. And each of those protections were won over time. And that's part of what we'll be looking at today. And finally, the unlawful practice is any practice that treats differently any member of a protected class during any part of the housing transaction, whether through intention or effect. Um, excuse me. So if you have these 3, you have housing discrimination. We mentioned that the first element is a covered dwelling. What do we mean by that? So a dwelling under fair housing law is to be construed as broadly as possible. There are very limited exceptions that we'll discuss on the next slide, but with those very limited exceptions, all places of residence that are not strictly commercial ventures, such as a hotel or motel, are covered by fair housing. Further, all aspects of the housing transaction are covered. So not only does the Fair Housing Act prohibit kicking a person out of their rented apartment based on their nation of origin, it protects that same person from similar discrimination in the rental application process, the process of securing a loan, in the appraisal of a home, and so on. There is an interesting edge case that we've been asked about a number of times, and that is mixed use dwellings such as Airbnbs or long term hotel stays. And while there's not always explicit case law or legislation dealing with this, fair housing law, the way it applies is usually based on the presence of a primary residence. So in the case of a hotel, for instance, fair housing usually does not apply because a guest in a hotel usually has a primary residence elsewhere. If someone's using a temporary shelter for the unhoused, however, um, the stay might be as short or shorter than someone else's stay in a hotel or Airbnb, but fair housing would apply because there is no other primary residence elsewhere. So again, yeah, broadly construed, the dwellings that are covered by fair housing, apartments, condos, college dorms, even housing construction sites and homeowners associations that aren't themselves dwellings but are associated with dwellings. These are all covered by fair housing. As I mentioned, there are limited exemptions, and we'll touch on them here. So first, the Fair Housing Act makes exemptions for religious organizations and other sorts of private clubs, uh, as long as the religion or club does not discriminate on other protected characteristic lines. It can give preference to people of the same religion if the housing they operate is not commercial. So, for example, if a Catholic organization owns a set of apartments, they can legally limit occupancy or give preference of occupancy to other Catholics if they otherwise adhere to fair housing law. There's also the Mrs. Murphy rule. This is owner occupied housing or a smallholder exemption. So the Mrs. Murphy rule is federally that a residence comprising 4 or fewer units that is presently occupied by the owner or a member of the owner's immediate family, that residence is exempt from fair housing law. Each state has its own version of the Mrs. Murphy rule, and here in Michigan, it restricts the residence to comprising 2 or fewer units. And a secondary aspect of the Mrs. Murphy rule that we'll mention here in a moment is that fair housing law also does not apply to homeowners who own 3 or fewer homes, um, who sell a house without the use of a broker. Um, it exists to protect small holding property owners. And then finally, we have senior designated housing, um, as well as housing under the Housing for Older Persons Act. This is split further into 2 types: housing for people 55 and older, and housing for people 62 and older. Within housing for people 55 or older, at least 80% of the units need to be occupied by at least one person who is 55 years old or older. And in the case of 62 and older housing, 100% of the units need to be occupied by someone of that age or older. In both cases, or excuse me, usually in these types of housing, disabled people of any age can live in the housing. And in both cases, further exemptions are made that would allow caretakers, employees of the housing complex to live there regardless of their age or family status. So there's a number of controlling laws that comprise fair housing law. And we'll begin up in the top left corner with the Civil Rights Act of 1866. So this was passed shortly after the close of the Civil War and the ratification of Constitutional Amendments 13 and 14. And the CRA of 1866 deals mainly with property rights and specifically prohibits discrimination based on race and color. Many years pass, and we have the strides of the activists in the civil rights movement of the mid 20th century. Despite all that activity, race-based housing patterns persisted. So while Black and Hispanic members of the US military, for example, were off in Vietnam fighting and dying for their country, their families here at home did often struggle to rent or purchase housing in certain areas because of their race, color, religion, or national origin. So following pressure from organizations such as the NAACP, especially the GI Forum as well as the intense pressure generated by the assassination of Martin Luther King Jr., pardon me, and the subsequent riots in more than 100 US cities, President Lyndon Baines Johnson signed into law the Civil Rights Act of 1968. Title 8 of this is what's now known as the Fair Housing Act. And the original Fair Housing Act establishes race, color, national origin, and religion as protected classes in housing transactions. The Fair Housing Act would then be amended in 1974 to add sex as a protected class, and then later again in 1988 to add family and disability status as protected classes. You'll notice before that 1988 amendment, we have the Elliott-Larsen Civil Rights Act of 1975. Just like federally, the United States has the Civil Rights Act. Each state has their own Civil Rights Act, and within that, a version of their own version of the Fair Housing Act. Here in Michigan, ours is the Elliott-Larsen Civil Rights Act, or ELCRA, or ELCRA. That was passed in 1975 and adds further protections against marital status and age discrimination. So returning again to the Fair Housing Act as amended in 1988, this adds familial status and disability protections. Pardon me. And when we move into the Elliott-Larsen Civil Rights Act of 2023, the legislature of Michigan updated the sex and gender protections to include all sexual orientations and gender identities, my apologies. And then finally, at the close of last year, we got a 5-bill package here in Michigan, including Senate Bills 205, 206, and 207 that add source of income as a protected class in Michigan. So to reiterate, those protected classes in blue, federally protected are race, color, religion, national origin, sex, family status, and disability. And here in Michigan, we add age, marital status, sexual orientation, gender identity, gender expression, source of income. So I mentioned the ELCRA. That is the controlling Michigan civil rights law. And that does list more than just age and marital status as protected classes, but those extra protections apply usually to cases of employment instead of housing. So for instance, weight is a protected class under Michigan law, but weight discrimination is seldom an issue in fair housing cases. Similarly, height is generally not what we'll find is the reason someone's not being allowed to rent. I mentioned earlier that I'll be using class and characteristics sort of interchangeably. again, it sometimes just makes less sense or is a little more awkward to describe someone as being in the class of families with children. Um, so yes, let's move on to source of income. As the newest protection, I think it bears a little time to discuss this. When we add source of income protections, we mean that a landlord cannot discriminate if a tenant's income includes Section 8 housing choice vouchers, public assistance, veterans benefits, social security income, supplemental security income, or other retirement programs. So 18 other states have laws that bar landlords from rejecting tenants based solely on their housing vouchers. And before this became statewide, affected in early April, 16 Michigan cities had previously adopted ordinances around source of income discrimination. So this five bill package also defines source of income within Michigan's ELCRA and allows renters to sue if they believe landlords are denying them housing over their source of income. These laws also allow complaints to be filed with the Michigan Department of Civil Rights for the same reasons. Uh, for the purposes of source of income protections, certain one time payments like monetary gifts don't count as income. Uh, and finally, landlords and property management companies with five or fewer holdings are exempt from these laws. So that's an expansion of the Mrs. Murphy law we saw, or rule we saw earlier. And then finally, we have four theories of four types of discrimination. They are discriminatory intent, and that's probably the simplest one. That's active mistreatment motivated by someone's protected characteristics. If you have a racist landlord, that's discriminatory intent. You have disparate impact, which is a facially neutral policy that nevertheless has disparate effects. Failure to accommodate generally pertains to disability, and that's disallowing reasonable changes that are needed for a disabled person to fully use and enjoy a dwelling. And then finally, we have retaliation. So that is mistreatment of a person following assertion of their rights. And with retaliation, the pardon me, the complaint that was made does not necessarily have to have been made about a bona fide moment of illegal housing discrimination. But if that person is retaliated against for raising that concern, that is always out of bounds. So, so for example, under disparate impact, if we consider the hypothetical where a property developer wants to build affordable housing specifically intended for occupation by nurses, because career is not a protected class, this would seem above board and maybe even noble, given that they're nurses. It's a respectable profession. However, in the developer's area, 95% of the nurses of the area are white. So if we attempt to limit access to the dwelling only to the area's nurses, this developer will have unintentionally limited access based on race, which creates a disparate impact. And remember that only behavior that involves one or more of the protected classes is illegal under the Fair Housing Act. So let's say a landlord refuses to rent an apartment to someone. Um, that refusal in itself has not violated the act. It's a covered practice and a covered property that are involved, unless it can also be shown that the landlord's actions based on their race, color, religion, sexual orientation or gender identity, disability, family status, or national origin. So if the landlord's action was based on another factor, such as a prospect's bad credit, no violation of the act has occurred. Um, Again, the landlord need not have been acting maliciously or otherwise with discriminatory intent. Uh, the potential for a disparate impact still prohibits the practice. Um, so I want to touch again here on failure to accommodate. That's a housing provider's failure to allow reasonable accommodations or modifications that would better allow a disabled person to exercise their right to full use and enjoyment of a dwelling. This is one of the more common practices cited in fair housing complaints. And indeed, disability is year in and year out the most cited protected characteristic in fair housing complaints. And we'll get into that a little bit more toward the end of this presentation. So these are the nuts and bolts basics of fair housing law. And we're going to now take a look at what makes the month of April so special to us in fair housing. So April is fair housing month. The Dr. Reverend Martin Luther King Jr. was assassinated on April 4th, 1968. 1 week later, LBJ signed the Fair Housing Act into law on April 11th, 1968. And Fair Housing Month is designated to honor those and other events. Now, of course, the impact of MLK on fair housing can't be overstated, but this year, we won't be foregrounding his work and legacy. We've decided instead to highlight some of the lesser discussed aspects of fair housing. So I mentioned that we'll begin by talking about racially restrictive covenants. Um, these are a sort of intermediate step that bridged the outright legislative segregation of neighborhoods and the prohibition of that segregation that's enshrined in the Fair Housing Act. So we'll look at those through a handful of their fundamental Supreme Court cases. And then, as I mentioned, with failure to accommodate, we'll conclude by discussing a luminary of the disability rights movement. Ed Roberts is the man's name. He was often called the father of the independent living movement, and he was instrumental in bringing disability protections under the umbrella of fair housing. The photo on this slide is one of MLK Jr. speaking in front of a lectern with microphones. So, to begin with racially restrictive covenants, obviously the historical relationship between race and real property or real estate ownership in the United States is checkered at best. Um, we went from outright denial of a person's ability to hold property based on their race to legally mandated segregation to de facto segregation upheld through practices such as restrictive covenants, redlining, and then to the nominal freedom of property rights under legislation such as the Fair Housing Act. This is not to say that segregation and discrimination do not persist, they certainly do. But through the story of restrictive covenants, I hope to illustrate that we can actually chip away at and sometimes dismantle the mechanisms that are used to uphold these ugly practices. So, in order to talk about restrictive covenants, we're going to look at two major cases. The first is Buchanan v. Worley of 1917, and the second is referred to in the literature as Shelley v. Kramer, but we'll be talking about its companion case, McGee v. Sipes. So Buchanan v. Worley is where restrictive covenants were born, and Shelley v. Kramer and McGee v. Sipes are where restrictive covenants lose their enforcement mechanism. So the nuts and bolts facts of Buchanan v. Worley. Charles Buchanan, who is a white real estate agent in Louisville, Kentucky, sold property to William Worley. William Worley, who is an attorney for the National Association for the Advancement of Colored People, or the NAACP, as well as their Louisville chapter president, built into his sale the following condition. Quote, "It is understood that I am purchasing the above property for the purpose of having erected thereon a house which I propose to make my residence. And it is a distinct part of this agreement that I shall not be required to accept a deed to the above property or to pay for said property unless I have the right under the laws of the state of Kentucky and the city of Louisville to occupy said property as a residence." End quote. So Worley, again, was a lawyer for the NAACP, and his legal savvy induced him to include that provision in his purchase request. It can reasonably be said that he knew full well that under the laws of the state of Kentucky and the city of Louisville, he did not have the right to occupy said property as a residence. He was one of Louisville's most foremost activists, and its president of its chapter of the NAACP. And so I think it can readily be seen that this provision was a calculated attack on those laws. Some people further speculate that Buchanan was acting as more or less a confederate of Worley, agreeing beforehand to challenge the purchase in the manner that he did. But that's not quite as important. I just find it an interesting little footnote. So yes, like I said, Worley was aware that Louisville had these zoning laws, these ordinances that forbade any black person to occupy a residence in a majority white area and vice versa, and that because of that ordinance, the sale could not be completed to Worley's satisfaction. Um, Therefore, Worley backed out of the sale, and Buchanan ended up suing Worley for the full payment. The picture on this slide is a sign that was common to many municipalities along the Mason-Dixon line and south of it that were quick to add these segregationist zoning laws after the passage of the 13th and 14th Amendments. And on the previous slide, we had a picture of William Worley. So the jurisprudence that underlies this unanimous ruling entails a lot of technical discussion of certain clauses of the 14th Amendment. And I will, instead of dipping into those too deeply, read this opinion from Justice Day, who was the Supreme Court justice at the time. We think this attempt to prevent the alienation of the property in question to a person of color was not a legitimate exercise of the police power of the state. It is in direct violation of the fundamental law enacted in the 14th Amendment of the Constitution, preventing state interference with property rights except by due process of law. So yes, the ordinance was struck down based on the idea that it surpassed legitimate grounds of police power by the state. It interfered with individuals' rights of property and ultimately was deemed to be unconstitutional. It did, however, oh, and I'm sorry, the photo on this slide is a placard commemorating the landmark civil rights victory of William Worley. The ruling did, however, have unintended consequences. It had an immediate impact on housing access, preventing governments from enacting laws and ordinances that are created specifically to achieve the means of racial segregation by limiting access to housing without due process. The decision, however, is limited in its scope and reflects the attitudes of race relations in America in the early 20th century. Elsewhere in the opinion given by Day, he calls racial segregation, quote, desirable and integral to the, quote, preservation of the public peace. It then goes on to state that this cannot be accomplished by laws or ordinances which deny rights created or protected by the federal Constitution. And so this gives rise to other practices such as fiscal zoning, redlining, and these racially restrictive covenants that allow people to achieve segregation through socioeconomic status instead of just straight up law. The picture on this slide is a photocopy of a restrictive covenant that said premises shall never be sold, transferred, or leased to any person or persons of the African or Negro, Japanese, Chinese, Jewish, or Hebrew races, or their descendants, or allowed to be occupied by any such person or persons, servants of the owner, or lessees accepted. An interesting little bit there, servants of the owner or lessees accepted. So the restrictive covenants that arose from Buchanan v. Worley are part of a set of laws that are said to run with the land. So these are agreements between the original, between its original author, excuse me. These covenants are agreements between the original seller and purchaser, and many state Supreme Courts held that they were outside the scope of the 14th Amendment. The idea being that once the first transaction was done, these were conditions upon the land and had nothing to do with the people making the agreement surrounding the deed later. So of course, restrictive covenants were not always related to the race, color, religion, or national origin of an occupant. They could also deal with what types of construction were allowed to be undertaken on a property, the easements that could be made among the neighbors of the property. So in the racially restrictive covenant, we find an older instrument twisted to suit the pursuit of segregation. And finally, with Buchanan v. Worley, I wanted to take a look at this image, which is where that placard stands today. This is the modern site of the property eventually purchased by Worley. I include it here as a reminder that fair housing affects everyone. So even though William Worley was certainly a canny actor, a keystone ruling of the Supreme Court of the United States wasn't concerned with some grand estate or some huge parcel of acreage. It's often shaped by everyday people pushing for their everyday rights, and those can yield historical moments. And we'll see an example of that with Shelley v. Kramer and McGee v. Sipes. Pardon me. So, the use of racially restrictive covenants erupted after Buchanan v. Worley, and it was struck down by the letter of the law with the companion cases Shelley v. Kramer and McGee v. Sipes. And now, it can be a little confusing here, as these two cases are more or less the same case as far as the Supreme Court is concerned. But in both instances, a Black family purchased real property while unaware of the racially restrictive covenant that ran with it. The Supreme Court condenses these cases and refers to them as Shelley v. Kramer for the purposes of oral arguments. But McGee v. Sipes is going to be our focus here. This happened, the events at issue in McGee v. Sipes happened in Detroit. So first we'll talk about Sipes v. McGee, which is how it was tried in the Michigan Supreme Court. And then the appeal, McGee v. Sipes, was, I'm sorry, I just had an error screen pop up, was how it was tried in the federal Supreme Court. So, Orsel and Minnie McGee in 1944 purchased a home at 4626 Seabolt Street in Detroit. So the original owners, or the owners who entered into the restrictive covenant, were John and Nita Ferguson, and they signed this restrictive covenant with a pool of their neighbors. The covenant restricted sales of neighborhood homes to white purchasers only. They then sold the house in that deed to Walter Joachim, and then the McGees bought from Walter Joachim. So they wanted a nice home in a decent Detroit neighborhood. They were able to purchase it. What they got along with it that was unintended were neighbors on Seabolt Street who insulted them and eventually sued them for buying while black while throwing rocks at their house. The McGees fought back. They took it to the Michigan Supreme Court and then the U.S. Supreme Court, where they were eventually represented by future U.S. Supreme Court Justice Thurgood Marshall. See him again here in just a moment. So this is a little bit just about the everyday nature of the McGees from the Detroit Free Press. In 1944, Orsel McGee was a maintenance supervisor at the Detroit Free Press. He was a mild-mannered and friendly man. He was known around the building as someone who was always willing to chat. In 1984, senior editor Neil Shine of the Free Press described McGee as a, quote, quiet man who laughed a lot, smoked cigars, and liked to go to the track. He had a small office in an obscure corner of the building, where coffee and conversation were always available without notice. They weren't NAACP lawyers, just normal Detroit folks who wanted a house. And so the covenant, the racially restrictive covenant, took the McGees by surprise. They had assumed that race relations had improved through the 1940s. And Minnie McGee talks to the Free Press in 1981 and says, quote, well, we knew about Dr. Sweet and the shootings and the long trial, but frankly, we didn't think about it. And she is referring to Ossian Sweet, a black Detroit physician whose purchase of an East Side home in 1925 led to a violent confrontation with neighbors, a death, and 2 celebrated murder trials in which no one was convicted. So from that ugly moment in 1925 into 1948, the McGees had mistakenly assumed that things had changed. Uh, the neighbors of the McGees, Benjamin and Anna Sipes, were the head of the suit filed against them. And when it was tried in Michigan, the ruling was found favorable to the Sipes in that the McGees were to be compelled to move. So you may notice the title here shifting from Sipes v. McGee to McGee v. Sipes. When we take this up to the federal Supreme Court with the help of the NAACP, the McGees there were represented by the NAACP at that point attorney Thurgood Marshall, and the federal Supreme Court, in a unanimous but short ruling, it was found 6-0 that racially restrictive covenants could not be enforced by the state. This vote was short because 3 judges had to recuse themselves because they themselves owned properties that held restrictive covenants. Thurgood Marshall was later appointed to the Supreme Court by Lyndon Baines Johnson, who, as we'll recall, signed the Civil Rights Act of 1968. This case does have an interesting little footnote in that Minnie McGee and Anna Sipes, throughout the progress of the case, did develop a close friendship. They had to maintain it discreetly so as to avoid harassment as the litigation progressed. And in the aftermath of the verdict, Benjamin and Anna Sipes came to regret their efforts to evict the McGees, and the 2 families eventually became close friends. So what is the legacy of McGee v. Sipes? The ruling effectively stripped racially restrictive covenants of their enforcement power. And then there is a lesser heralded case, Heard v. Hodge, that reinforced that at the federal level. Tends to be the case that most housing transactions are on federal land, so it's less discussed. So despite their unenforceability, though, many racially restrictive covenants still exist in modern home deeds. And the covenants were not always, in the case of McGee v. Sipes, Sipes McGee, they were not always entered into by like-minded neighbors who were attempting to restrict the racial makeup of neighborhoods. They were often required by lenders before money would be given to developers. And in Ann Arbor, here in Michigan, a group led by Professor Michael Steinberg, which is the University of Michigan Law School's Civil Rights Litigation Initiative, they've undertaken a project to assist homeowners in Washtenaw County with locating and removing racially restrictive covenants from their homes. And so here again is the placard commemorating the Orsil McGee house. This designates it as a Michigan historical place. And I cannot read everything that's on the placard, but it is very similar to what I've been saying. So now I want to take a moment to celebrate one of the champions of fair housing. I mentioned at the top that disability is the most cited protected class in fair housing complaints. The National Fair Housing Alliance, or NAFA, in their 2024 Fair Housing Trends Report shows that last year, 52.61% of fair housing complaints cite disability as the protected characteristic at issue. Disability advocates and activists were instrumental in the passage of the Fair Housing Amendments Act of 1988, and no small part of that is due to Ed Roberts, who is a luminary in the civil rights, the disability civil rights community. So who is Ed Roberts? Edward Vern Roberts contracted polio in 1953 at the age of 14, which was 2 years before Jonas Salk developed the vaccine. He was left paralyzed from the neck down, except for some limited finger mobility on one hand. He could also move a few of his toes. This paralysis, however, did force him to sleep in an iron lung. He would often spend much of his awake time in the iron lung as well. But the large 800-pound iron lung was necessary for his survival. Uh, Originally, he attended his primary school um, through the telephone, and eventually his mom said more or less, "You need to get out of the house. You need to go to high school." And so, by attending school, he was able to teach himself to face his fear of being stared at, and was able to stop thinking of himself as a helpless cripple and instead as a star. So he is sometimes called the father of independent living. Um, when he was admitted to the University of California at Berkeley is when he began to seriously organize. So I mentioned that he was, going to high school taught him to view himself as a star. Uh, However, his high school did initially attempt to deny his graduation as he had completed neither the driver's training nor physical education course requirements. And so he and his mother petitioned the school board for his diploma. This is where it said that his activism truly began. Uh, he was accepted into Berkeley, but the university claims that it was unaware of his disability when they accepted him and therefore refused to admit him because the iron lung would not fit in the dormitory. And as one UC Berkeley dean told him, quote, "We've tried cripples before and it didn't work." So Roberts needed Berkeley to accommodate the 800-pound iron lung that he needed to use for his own survival. And instead of trying to fit it into a dorm, they found a room in an empty wing of a university hospital that was prepared for his use, and he agreed to this um, only only on the condition that it be set up as a dormitory and not a medical facility. It was about living normally, uh, and that victory broke the ice for other students at Berkeley living with a disability who began to sort of gather around Ed Roberts. And this group, alongside Ed Roberts, who called themselves the Rolling Quads, began to develop a political theory of independent living. They chose the name the Rolling Quads specifically to get people's attention. People weren't used to hearing disabilities spoken of with positivity. Uh, and this group also got people's attention by illustrating how far Berkeley still had to go to be considered an accessible campus. As they went on, Ed Roberts and the Ruling Quads established the Physically Disabled Students Program, which was a group established by and for disabled students. They offered things like wheelchair repair, peer counseling, and other accommodating services. They went out into the community and advocated for curb cutouts. Uh, the In 1976, well after his graduation, Roberts was appointed director of the California Department of Vocational Rehabilitation, uh, which was an agency that in 1962 had deemed Ed Roberts too disabled to hold a job. So, as the director, he facilitated the establishment of independent living centers throughout the state. He also traveled to lobby for disability rights all through the United States, as well as other places around the world. And after his death, in his honor, a campus was constructed at Berkeley. Uh, it's a fully accessible transit hub, and the aptly named Ed Roberts Campus is a national and international model that is dedicated to disability rights and deliberately designed with universal access in mind. The Berkeley Center for Independent Living, which was founded in 1975, was the first center for independent living in the United States and was a big part of shaping the conversations that would lead to the Fair Housing Amendments Act of 1980. But in the Fair Housing Amendments Act of 1988, disability and family status were added as protections under the Fair Housing. Uh, this entitled people with disabilities all the protections of the Fair Housing Act, and the key phrase is the right to full use and enjoyment of their dwellings. Um, so reasonable accommodations are changes to rules, policies, procedures, and reasonable modifications are changes to a dwelling's physical space that better allow a person the full use and enjoyment of their dwelling. So the image here is a picture of Ed Roberts and a quote, "Disability is a strength. Our number one issue is still old attitudes toward us, and those old attitudes see us as helpless and unable. Disability can make you very strong and very able. And a final footnote here, January 23rd is Ed Roberts Day. So we have Fair Housing Month of April. And in January, we have Ed Roberts Day. So some closing thoughts. Patricia Fran of the Chicago Area Fair Housing Alliance said during the height of COVID-19, during the height of the uncertainty of COVID-19 that, quote, with any crisis, it's those who are already in vulnerable positions who are going to have the earliest and harshest impact. 5 years on from that height, that uncertainty is now well reduced, but of course, new crises will come. And this Fair Housing Month, I think it bears remembering the impact that these crises may have on our most vulnerable neighborhoods. And that we should think of April as a month of redoubled effort and extra compassion. Finally, this quote from Dr. King in 1966, "We are here today because we are tired. We are tired of paying more for less. Now is time to make real the promises of democracy. Now is the time to open the doors of opportunity to all of God's children." I believe that opportunity begins with having fair and stable housing. And I will now open the floor to any questions.